The Second Amendment of the United States Constitution is a cornerstone of American liberty, a fundamental pillar that supports the very essence of freedom in this nation. It guarantees the right of the people to keep and bear arms, a right that has been fiercely protected and debated throughout American history. This right is not granted by the government, nor is it a privilege that can be taken away at will. It is an inherent right that pre-exists the government, a natural right that belongs to every individual. The Founding Fathers recognized the importance of a well-armed citizenry, understanding that it was crucial for the preservation of liberty. They knew that a well-armed populace is essential for a free state, a safeguard against tyranny and oppression. The Second Amendment is short and to the point, yet its implications are profound and far-reaching. It states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. These words have echoed through the centuries, a testament to the enduring value of this right. The meaning of this amendment is clear, yet it has been the subject of much interpretation and legal scrutiny. The right to keep and bear arms is a fundamental right that shall not be infringed, a right that empowers the people and ensures their ability to protect themselves. Today, the Second Amendment is more important than ever as we navigate a world filled with uncertainties and potential threats. We live in a dangerous world where the safety and security of our homes and communities can never be taken for granted. The threat of tyranny is real, a shadow that has loomed over many societies throughout history. The Second Amendment protects us from these threats, providing a means of defense against those who would seek to undermine our freedoms. It ensures that we, the people, have the means to defend ourselves, our families, and our freedom, a right that is as relevant today as it was at the founding of our nation. The Second Amendment is not about hunting or sport shooting. It is about freedom, the freedom to live without fear of oppression. It is about the right of the people to defend themselves against any threat, foreign or domestic, a right that is integral to the American way of life. It is a right that must be protected at all costs, a foundation of freedom that we must cherish and uphold for future generations. The Second Amendment is essential for self-defense, a cornerstone of American liberty. It empowers individuals to protect themselves, their families, and their property from criminals, ensuring peace of mind. The right to self-defense is a natural right, deeply rooted in the principles of justice and fairness. It is not granted by the government, but is an inherent right that exists independently of any laws. It is inherent in our humanity, a fundamental aspect of our existence and dignity. Every person has the right to defend themselves from harm, using whatever means necessary to ensure their safety. The Second Amendment recognizes this right and protects it from government infringement, safeguarding our freedoms. When seconds count, the police are often minutes away, highlighting the importance of personal preparedness. In a life or death situation, individuals cannot rely on the government for protection, making self-defense crucial. They must have the means to defend themselves, ensuring their immediate safety and that of their loved ones. The Second Amendment ensures that they have that right. Gun ownership deters crime and promotes a safer community. Criminals are less likely to target individuals they believe may be armed, reducing the likelihood of crime. This benefits not only gun owners, but also society as a whole, fostering a sense of security and responsibility. The Second Amendment is not just about protecting individuals from criminals. It is a broader safeguard. It is also about protecting individuals from tyranny, ensuring that power remains with the people. The Second Amendment also recognizes the importance of a well-regulated militia, a concept deeply rooted in the history of our nation. A militia is a group of citizens who are trained and equipped to fight, ready to defend their communities and their country. They serve as a defense against foreign invasion and domestic tyranny, standing as a bulwark against threats, both external and internal. The Founding Fathers knew that a standing army could be a threat to liberty, having experienced firsthand the dangers of a powerful military under tyrannical rule. They had just fought a war against a tyrannical government that used its standing army to oppress the people, and they were determined to prevent such oppression in the future. They wanted to ensure that the new government they were creating did not have the same power to subjugate its citizens. The The Second Amendment guarantees the right of the people to keep and bear arms in order to form a well-regulated militia, a crucial safeguard for freedom. This militia would be composed of well-armed, ordinary citizens, not professional soldiers, ensuring that the power remained with the people. They would be armed and trained to defend their homes and their country, ready to respond to any threat. The militia would serve as a check on the power of the government, a necessary balance to prevent overreach. If the government ever became tyrannical, the people would have the means to resist, ensuring that liberty could be preserved. The Second Amendment is as relevant today as it was in the 18th century, a testament to its enduring importance. The threats to our liberty may have changed, but the need for a well-armed citizenry has not. The principles remain the same. We still face the threat of foreign invasion, a reality that necessitates vigilance and preparedness. And we still face the threat of tyranny, albeit from within our own government. The Second Amendment ensures that we are never powerless in the face of such threats. The Supreme Court has affirmed the individual right to keep and bear arms. In the landmark case of District of Columbia v. Heller in 2008, the court struck down a law that banned handgun possession in the home. The court held that the Second Amendment protects an individual's right to possess a firearm unconnected with service in a militia, and to use that arm for traditionally lawful purposes such as self-defense within the home. This decision was a major victory for gun rights advocates. It affirmed that the Second Amendment protects an individual right, not a collective right. The Heller decision was a watershed moment in the history of the Second Amendment. Section 5, the right to bear arms, not without its challenges. Despite the clear language of the Second Amendment and the Supreme Court's affirmation of the individual right to keep and bear arms, this right is under constant attack. Gun control advocates continue to push for laws that would restrict or even abolish this fundamental right. They argue that these laws are necessary to reduce gun violence. However, there is no evidence to support this claim. In fact, many studies have shown that gun control laws have little or no effect on crime rates. Gun control laws only serve to punish law-abiding citizens while doing nothing to stop criminals. Criminals, by definition, do not obey the law. They will always find ways to obtain guns, regardless of what laws are in place. Gun control laws only serve to disarm law-abiding citizens, making them more vulnerable to criminals. Any and all gun control regulations are unconstitutional. The Constitution strictly forbids the government from infringing on any of our rights. Nowhere in the Constitution is the power listed for the federal government to regulate firearms in any way, shape, or form. Section 7, assault weapons bans. Ineffective and unconstitutional. Another common gun control proposal is to ban so-called assault weapons. These bans are based on the misconception that certain types of firearms are more dangerous than others. However, the term assault weapon is a political term, not a technical one. There is no clear definition of what constitutes an assault weapon. Bans on assault weapons are ineffective and unconstitutional. They infringe upon the Second Amendment rights of law-abiding citizens. Section 8, magazine capacity limits, infringing on self-defense. Gun control advocates also frequently target magazine capacity. They argue that magazines that hold more than a certain number of rounds are unnecessary for self-defense and only serve to increase the lethality of mass shootings. However, there is no evidence to support the claim that magazine capacity limits reduce gun violence. Criminals, by definition, do not follow the law and will obtain high-capacity magazines regardless of the law. Magazine capacity limits put law-abiding citizens at a disadvantage in self-defense situations. In a self-defense scenario, every second counts, and reloading can be the difference between life and death. Section 9, the Second Amendment, a legacy of liberty. The Second Amendment is an essential safeguard of American liberty. It protects our right to self-defense, deters crime, and serves as a bulwark against tyranny. The Founding Fathers understood the importance of an armed citizenry. They knew that the right to keep and bear arms is essential for a free people. The Second Amendment is as relevant today as it was in the 18th century. It is a cornerstone of our freedom and must be protected at all costs. The Second Amendment is not just about guns, it is about freedom. It is about the right of the people to defend themselves against any threat, foreign or domestic. It is a right that must be preserved for generations to come. In conclusion, the Second Amendment is clear in that it protects the pre-existing individual right to keep and bear arms from government infringement. The Founding Fathers were very clear there were to be no limits to the Second Amendment. It does not say the right to keep and bear arms shall not be infringed unless it looks scary, shoots real fast, or is really dangerous. Shall not be infringed means exactly that. No limits on type or caliber, no background checks, no purchase restriction, no carry restrictions, no permits or permission slips required. This is a right that predates the Constitution and is endowed on every citizen no matter where you live. Anything the government or the standing army can possess is constitutionally legal for the citizens to keep and bear. Arms means arms. The founders wanted the citizens to be as well armed as the government in case the government became tyrannical and oppressive. Stay frosty, my friends. Keep your head down and your powder dry.